Welcome, everyone, to this short webcast on guardianships ripped from the headlines. So, my name is John B. Henry III. I'll be your presenter today, taking you through this course on guardianships and what our most recent, most famous guardianships in the headlines can teach us about many things that are related to a guardianship and ways that perhaps these guardianships could be avoided. So let's go through the first. Britney Spears, the beginning. In 2008, Britney Spears suffered a public mental health crisis. Britney spent 2 nights in Los Angeles Cedars-Sinai Medical Center after she failed to turn over her kids to her ex-husband, Kevin Federline, resulting in a 3-hour standoff with cops. In fact, reports indicated that Spears tested clean for substances. Some reports say that her behavior was the result of a purple monster. In my mind, as an aside, I don't know. I'm thinking like the purple people leader when I hear purple monster, but that's not what this was. This was purportedly a vodka and prescription drug cocktail mix. Um, there are some doctors who've commented on this and said with the 100 pills that were supposedly part of that cocktail, it would not be possible for a human being to survive ingesting such a cocktail. Um, that aside, this latest breakdown that happened in 2008 and that year was a result of a year and a half of what some called bizarre behavior, including shaving her head bald and beating a car with an umbrella. And here's a picture of that umbrella incident. So, what are the goals of this presentation, right? Not just to publicize things that have been publicized quite a bit in this story, one of the last stories that are from the headlines. It's to give us a starting point to talk about something that has been highly unpopularized. As we will talk, a lot of guardianship history and issues surrounding it have not been the product of popular public discussion even though guardianship has been a creature of hundreds and hundreds of years of it has hundreds of years of legal presence, not only in the United States, but also in the British common law system and also in Roman law. And obviously, its antecedents in other laws as well. We'll also take a brief look at current Texas legislative history, because of course, I mean, this is a CLE. We got to do some law. I know, but we're going to make it as interesting as possible. We're going to be exploring case studies throughout this presentation, both from obviously the life of Britney Spears and a couple of other famous persons, but also ones that aren't so famous. And what I'm hoping that this presentation will do will help us question what makes them any different, right? What makes this famous person? Maybe it's Britney Spears and other people who I, of course, redacted the names and to protect the identity of the innocent, but to compare them and why are their outcomes different? If any, if that's something we can assess through the presentation. And definitely there's thought food in there. And then providing a decision tree for considering and determining feasibility of supports and services and alternatives to guardianship. Certainly these guardianships having made the headlines, certainly being featured in a recent movie, I Care a Lot. Uh, there's definitely questions about whether a guardianship is necessary and how do you determine that? With the that have made the headlines, part of it has just been the nature of people who are involved in their popularity. But it does highlight also the issue that I think has been a creature of the development of law, which is to try to understand how do we make a decision that guardianship is necessary. And so those are the things we're going to tackle today. So let's begin with discussing a brief history of guardianship. I know it it can be dry, but the history of guardianship is quite interesting because there isn't really a lot of it in recorded law. What we do understand is some of the earliest examples in law generally, as I mentioned earlier, are protective arrangements for minors who inherited property, right? And so when we think about the genesis of guardianship, the genesis of conservatorship law. We're thinking about people that we just commonly accept don't have capacity to manage their affairs. So, as we look toward the trajectory of the development of guardianship, that is one assumption among many that certainly many advocates, many groups are now doing work to disarm and dislocate this idea of the disempowered, the disenfranchised, the person without the ability to make decisions in all realms concerning either their property or their person. Um, some of the earliest laws recorded in the United States included provisions for guardianship, like in Massachusetts. Quite interesting. Legal scholars have commented that until recently, guardianship and protective proceedings have gone without much, if any, scrutiny. In the early 1900s, we see more decisions delineating depression or emotional disability from someone who is non-compos mentis or not of sound mind. And this development and distinction, of course, again, it's what I was saying, the trajectory of law, this attempt in the law to make distinctions, delineations, um, to say that there are levels and layers of capacity, or certainly what we're seeing in more modern discourse about guardianship, the levels of capacity, the layers of capacity, and are we dealing with people who have episodic issues? And so that's certainly in some of the stories we're going to talk about and go through, make us bear out these questions and thoughts, and certainly what we think about them as individual people, but also how we can think about them as legal practitioners. Most people committed, interestingly, in 1900, for example, were socially mischievous, commonly referred to as deviants. And I give you a citation there to an article and that goes into this idea of commitment and how it was used at the turn of the 20th century. Those who were deemed incompetent were generally older people who began to decline. Again, this idea of the protective proceeding or guardianship, conservatorship, civil commitments is rendered in this lifeblood of decline or inability as a thought process as to someone who needs protection. The distinction of insanity versus incompetence was frequently the question considered by the court at this time. So again, we begin to see the bearing out and the distinctions in this turn of the century analysis of of conceptually the what someone's mind is able to do. Unfortunately, it seems quite either or insanity or incompetence, but it's the beginnings. And so let's fast forward a little bit. There are other issues in the background as we're looking toward the development of the United States and history and these ideas of protective proceedings and guardianship and conservatorship. At this same time in the background, we have other issues. Towards the end of the 1800s and at the turn of the 1900s, there was a eugenics movement, right? And we're not just we're talking about located here in the United States at present, and not uh, its equivalent across the shores, right? And so what we're looking at from the United States perspective was eugenics was the avoiding of mating and preventing the production of those without good genes, right? And so that included certainly people of color, but that also did include people with mental health defects, that were considered among those deemed to be undesirable during this movement. There were tens of thousands of people that have been reported to have been sterilized due to the eugenics movement and this thought process of purifying the gene pool, right? And that did include persons who were mentally infirm, right? And so as we're engaging in this thought process, this thought project of guardianships today in 2022, right? And we're looking at people like Britney Spears, like Wendy Williams, and other persons who may have questioned capacity, like Kanye West, for example. These are located in ideas that go back hundreds of years, including where people were sterilized. I mean, and there's certainly other issues in this background. For example, the issue of housing for those who have mental illness has been an issue for many, many centuries long. As early as the 18th century, there's evidence of asylums which were created for the quote mentally ill. And at times were used for the severely mentally ill, and that's still the case even here in Texas and in the United States. For those who have severe, very severe mental illnesses, there are dedicated facilities that are residential in nature. This idea of force protective facilities continued throughout the centuries and throughout countries, including the United States. What's most interesting, if one was not aware otherwise, it's not until we see the mid 1900s a movement to deinstitutionalize those who were receiving mental health services in favor of the community. So, again, when we look at this idea and fast forward to our guardianships today, and not just those of famous people, and we look at the opportunities available, this is a dialogue many centuries old, um, of where they live, who they're able to mate with or not. And so it's important to locate these discussions in this history to have a broader perspective of the battles that people are facing today. And of course, we can even bear out further other axes that should be considered and this idea of the guardianship protective proceeding, and why, when we fast forward today, a dynamic analysis is needed to understand the struggles that people are facing. That would include, as I mentioned, race, that would include religion, gender identity or expression, sex and sexuality, mental health stigmas, financial limitations, and of course, the idea of politics. And we're not going to get into any of those today, but as we look at the layers and accesses of the people involved, all these factors come into play and are a relevant part of the analysis when considering a guardianship. So here's just a plain Jane example. Again, the name has been changed to protect the individual, but here's an idea of a case that I've handled. It's Harold. He's been under guardianship for a period of at least 4 years. He was placed under guardianship because he would completely neglect himself and fail to maintain his person and his property. He would stay at home and eat steak and cake while the world around him went on. However, since his stay at an assisted living facility, he has received medication management and feels as though he should be restored to capacity. After you're appointed as an attorney ad litem, you've been retained to represent the family who's opposing his restoration. Let's say you interview, you learn about him, and you see the request for restoration letter. What do you do? Right? This is perhaps something we see more commonly, and that may be seen more commonly in practice, right? We're not dealing with the Wendy Williams, the Britney Spears, but we are dealing with people not in dissimilar state, right? As we'll see from the story of Britney Spears, she was absolutely isolated, right? From reports in her own testimony before the conservator court in California. This idea of isolation, this idea of the forced treatment, the idea of continued not being of sound mind, right? Or non compos mentis. When I started practicing like 10 years ago now, a little over 10 years ago now, there were still guardianships and references in guardianships as someone NCM or non compos mentis, someone without the sound mind, right? And so when we have that adjudication, then we can't then use it to say that this person could never have capacity again, or capacity on varying levels at life decisions that have to be made in a person like Harold's life, which is also the case in the case study of Britney Spears. um, so we're going to take a brief look. I know we're going to talk about Texas law again. we need some credit. So here's the current Texas law. The policy and purpose of a guardianship: a court may appoint a guardianship with either full or limited authority over an incapacitated person as indicated by that incapacitated person's actual, emphasis added, actual, mental or physical limitations, and only as necessary to promote and protect the well being of the incapacitated person. The statutory section at 1101.001A certainly emphasizes the importance of person centered planning. I think when we think about not only Harold, we think about Brittany, we think about Wendy, we think about the other stories that allude to this idea of a need for protective person, whether popular or not. We have to remember it's about the person. Right, and I think that gets lost in our discussions, the salacious points, the dregs, the bits, the burnt ends of it, let's say, are the things we often comment on, but we forget that it's the person, right? It's a person-centered plan and need. And so um, the statute in Texas highlights that. And we see its analog, or that same development with the Uniform Laws Committee and the Uniform Guardianship and Protective Proceedings Act, and Jurisdiction Act, UGOPSHA. We see that this similar development is also happening on a national sphere about the idea of the person and this idea of creating limited guardianships. Further in our Texas statute, though, at 1101.001B, we see that in creating a guardianship of a limited nature over an incapacitated person, the court shall design the guardianship to encourage the development or maintenance of maximum self reliance and independence in the incapacitated person, including by presuming that the incapacitated person retains capacity to make personal decisions regarding the person's residence. Um, Very, very key in the idea of what a guardianship is. It's not just a judicial finding that we don't revisit, right? That when, as we're counseling people, as we're looking at this idea of a protective proceeding, it's based on need, it's based on the individual. It's also based on the fact that if it is used, it's meant to ameliorate, to make better, to do better, and to have the person be maximized and be empowered. And we see that codified in our Texas statute. So, what about the legislative history? I'm only going to go briefly into this because there's a lot to get through in this presentation. But the legislature has tasked lawyers, judges, and courts generally to exercise best efforts to make reasonable measures to promote the independence of an individual who may need assistance with various tasks in life, as we've talked about. Those recommendations to change how guardianships are established and continued were meant to address expected growth, the number of disabled individuals, potential guardianships, and the attendant demand on the judicial system. The proponents of the legislative changes maintain that they were meant to ensure that guardianships were used as a last resort, to educate lawyers in the court handling guardianship matters, and to create a balance in guardianships, which can be useful tools that can nonetheless be costly and an excessive restriction. When we look at the idea of, or look at the case study of Britney Spears' guardianship, it's very well publicized and noted her conservator's compensation going into the millions. I mean, what a job, right? The court that authorized that. Wow, did she not have any other professionals that were being paid that had a managerial contract review capacity? How did they come to this idea that the guardian was entitled to effective millions of dollars in compensation, right? But even with that example aside, right, that's kind of a broader one. That's not the typical guardianship. You're not going to see a guardianship of that size estate, but you will see the issue of court costs. You will see the idea of compensation, and you will see the idea of restriction. And so those are definitely things to be keeping in mind as you're structuring a guardianship and assisting the client and advising the client on their fiduciary duty in maintaining the ward's life. And sometimes the guardian's compensation can run afoul of that, right? If there isn't sufficient assets on a longer term analysis for continued compensation. And can be a difficult question when that has to cease in a guardianship proceeding. So the opponents of it in the 84th legislature found that it was unnecessarily burdensome, especially in cases where guardianships were just clearly necessary, monopolizing factor in the bar, and a conflict of interest for attorneys at litem who could be compelled to report to the court in violation of their attorney-client privilege and confidentiality to the proposed incapacitated person. So let's look at that. It's very interesting. So the state of affairs in county courts. This is data coming from the Guardian Abuse, Fraud, and Exploitation Deterrence Program that's housed within and operated under the auspices of the Office of Court Administration with the Judicial Branch Certification Commission. These ongoing studies that if you're practicing guardianship law here in Texas, you're seeing an ongoing review and the court saying, oh, the OCA has been here today. Well, they've actually been collecting a lot of dynamic data, including the following. The most recent study included 153 counties and 33,417 guardianship cases in the county courts. Out of those guardianships, 17,179 were recommended for closure. Wow, right? Like compliance issues. What did they see? 33% of cases were missing annual reports, 43% of cases missing initial inventories, 44% of cases were missing annual accountings, 43% of cases were just out of compliance. Almost half. It's overwhelming, right? And then 4,193 deceased wards, right? So I think when we look at these statistics, we can absolutely see the need for ongoing guardianship compliance, perhaps reformation. And some of this obviously comes as a result, and just the again, forgive the nerdy in me. We are not in a discretionary jurisdiction where the guardian or conservator is empowered to make decisions without um, several filings to the court that are certainly comparatively in the non-discretionary. So jurisdictions like Texas is. So you might see an annual report in a discretionary jurisdiction where the court appoints the guardian and says, report to me at the end of the year, in a very short form accounting that's maybe 2 pages, and where full bank statements, receipts are not regularly required for approval of accountings. Admittedly, there is work to do when you're appointed as a guardian, and explaining that to guardians who are or conservators coming to Texas from other jurisdictions. They definitely feel overwhelmed with the amount of information our courts can require. So I think that's part of the compliance issue that we see. It's just the level of detail and expectation under the law here in Texas. But certainly, this idea of it being out of compliance does give us pause. Are we really, are these number of wards being maximized? Are they being powered with self-reliance? We don't know. There's a lack of reporting on that. So let's look at statutory probate courts. Most recent study included 9 counties and courts with 26,965 guardianship cases being reviewed. 11,226 were recommended for closure. Compliance issues, 19% of cases were missing annual reports, 17% of cases were missing initial inventories, 31% of cases were missing annual accountings, and 21% of cases were just out of compliance as an overall metric. And then 1,701 deceased wards. So again, when we look at this idea of the need for legislative change, we look at the idea of a guardian in their ongoing duties, we can definitely see a continuing need to observe the idea of compliance. And then also, I think more broadly and more importantly, what are the ending outcomes for persons under protective proceedings in Texas generally, certainly in the nation generally, and it definitely bear these questions out, knowing these statistics. I'm going to just say, not Ahura. No, no, right? It may be a not well known, but the actress Nichelle Nichols, or the actress who plays Star Trek's Uhura, has been under guardianship proceedings since 2019. There's an ongoing battle between her son, manager, and close friend. In early 2019, Nichols' son, Kyle Johnson, was appointed her conservator of the person and estate. He moved her to New Mexico, reports say, to take better care of her. Nichols' manager, Gilbert Bell, complained of the guardianship and his inability to visit with Nichols, though the son said he began the whole process because he found out Bell transferred Nichols' home to himself. Nichols' friend, Angelique Bassett, says that neither Bell nor Johnson have Nichols' best interest in mind. Um, there's a lot of takeaways in this, but one is this idea of sort of a family friend infighting. We definitely are seeing more of these. In conversation I presented to the Department of Family Protective Services last year on this idea of guardianship, alternative supports and services, and conversations with some of the attorneys with the FPS on the APS side. They're definitely seeing more cases like this, people fighting over what appears to be resources, and certainly in more of the cases they have commented to me on. Involved, I mean, not with specificity, of course, it's confidential, but what, of course, the general tenor of what they're seeing is family fighting over assets. And certainly, again, bears out the question more generally: is the guardianship really necessary? Is it only necessary because we have people fighting and it's really a hot mess? I don't know. But all I can say at the end of it is not Ahura. Unfortunately, it is Ahura on this one. She's under guardianship. So, what's the statutory framework in supports and services and alternatives to guardianship in Texas? Alternatives to guardianship are actually codified at 1002.015. That would be the execution of medical power of attorney, the appointment under durable power of attorney, mental health directive, appointment of a representative payee to manage public benefits, establishment of a joint bank account, a management trust, a special needs trust, a designation of a guardian before the need arises, and establishment of alternate forms of decision making based on person centered planning. You'll see that corollary or the similar provision under supports and services, and I think this one is very key to problem solving when we look at these cases, which is the alternate forms of decision making, the alternate those supports and services or anything else that helps to avoid the guardianship. It's important to see the individual for themselves. You know, we look at Brittany, we look at other cases where people have had mental breakdowns. Are they receiving continued services? As a question. And when we look at the idea of supports and services, are they receiving medication management? Right? Are they receiving the right kind of medication? Is their medication being reviewed? Right? So those are all things as we're looking at a guardianship are definitely first blush level look. So are these things in place and are they being reviewed or modified, if they can be, to conform to what the person actually needs at that time? And so we can look at that idea of supports and services, which are means available, formal and informal resources and assistance, which can be meeting the individual needs for food, clothing, shelter, physical or mental health, individual financial affairs, personal decisions regarding voting, operating a motor vehicle, and marriage. It's a little delay. Let's see. Okay, I'm being told to click the mouse to see if it will make the arrow go. And are we gonna? Thank you for the assistance. See, support and service, informal and formal. Learning lesson there. I'm telling you. Okay, so what are some examples? Someone clicking the button for you, adult care, daycare, adult foster care, assisted living facilities, case management, bill paying, employment assistance. The list goes on. I think what's more important are that these are examples. These are starting points. But they're definitely important to making that analysis in the first place. If someone comes in saying there's a continued need for guardianship or there's a need for guardianship, well, what's in place for that individual? Do you have someone who's 35 and on the spectrum? Are they in a day program? Do they have a job? Do they have other diagnoses? Are those diagnoses being managed and treated? Do they feel empowered? Those are all questions in my practice that I take the time to understand each guardian, proposed guardian or ward that comes in. And in my opinion, which is my opinion, that I think the attorney assessing this should be putting that homework to the client. Okay, you don't have a case manager, you don't have an adult daycare, you don't have them on benefits. Okay, you must go do that because they're in need of services. Um, there are service coordinators with benefits programs. You don't have to become a specialist. If your clients have the resources, they can pay for assessment by private care managers, right? There are these options available. And it goes back to that statutory purpose, which is maximizing the individual, and certainly for the purposes of self reliance and independence. Okay, so it's Brittany. She's free. Spears has described years of isolation, medication, financial exploitation, and emotional abuse. Britney Spears has previously attempted to retain counsel during the years long battle of her guardianship or conservatorship, but was denied that opportunity previously because the court found that she lacked capacity to retain counsel. She fought for years of the removal of her father, but most recently garnered success by way of the termination of the guardianship. The end of the conservatorship came a few months after Spears was reportedly able to speak about the terrors she endured under the guardianship in open court for the first time, including testimony of forced medications and control of intimate details of her life. So interesting, the importance of having a voice, right? And what that voice can lend to someone's success in court, right? I mean, we can take it out of the realm of it being Brittany and taking it down to just anyone. The importance of going before a judge and being able to speak on record about issues and certainly being empowered to do so. Led to her own success apart from the media hype that has surrounded the Free Britney movement, right? Which this maybe perhaps is a crowning jewel in that, but it certainly highlights the importance of documenting those issues. And the idea of medication. Certainly, also in Brittany's case, there were reports of her being surveillance in her bedrooms or in her home. That she was required to have protective technology to prevent her from uh, becoming pregnant, right? So when we start again, that idea of the individual, are they isolated? Are they able to express themselves by sexual identity? Brittany is a perfect example of that, but only highlights a years long battle, and it's not just her. I've had a guardianship last year or the year before last. Again, won't mention names where the guardianship is established, but one of the guardian is a family guardian, and after their sister had been all around, she didn't have a fixed place to live. There was a breakdown in her life after an abusive relationship with her husband. It caused her to spiral various issues, and from all accounts, she needed the help. But one of the issues the siblings asked was of their adult sister, can we ask that she be sterilized by the court, right? And so still this idea of the person needing protection, including, uh, I guess, from having children or sexual expression is still something that is absolutely being encountered by many people and not just the famous. So in Texas, as many are have, um, and that's as of 2015, where any attorney representing someone in a guardianship proceeding is required to be certified. The duty of the applicant is they must allege that supports and services and alternatives to guardianship have been considered, but found not to be feasible. In my view, again, admitting that it's a point of just advocacy. If your client is averring that in a pleading, then they probably should have actually done so, explored and tried alternatives to guardianship and supports and services, and in reality have found them not to be sufficient and not just have alleged it as a standard part of a pleading. Because again, it's those decisions and it's that mind frame that's important and can make the difference in an individual's life generally beyond the idea of just getting them to a point of being maximized, but sometimes doing anything at all. There was a case where I was an attorney at Lightem, and the mother absolutely loved her daughter, but would leave her at home under lock and key with no one there. She had a Downs designation. For all, nothing ever happened of any reports that I was ever made aware of, but she was left there at home alone in her room because her mom had to go to work. Very difficult situation, right? We can understand the many layers and the things in the background, but she was an adult, and she was an adult, and um, so part of my requirement before her mother was appointed was for her to seek some day program, some services for her daughter so that she would not be left at home. And my hope, right, I'm an attorney at Lightem in establishing the guardianship, is that that began a dialogue of something that also created just future discussions of plans. In that particular case, there weren't family available outside of the mom, outside of people of her age. So then it was going to be a question later of future planning. Would daughter just be thrown into a personal care home or ICF that she had not had socialization, and for a period of maybe 20 or 30 years after her mother's passing? Those are all very difficult questions and deserving of compassionate thought processes. But it's one that we have to explore when we think about guardianship, because ongoing that individual's rights will be restricted um, unless a restoration is sought in the future. So again, the duty of the attorney ad litem is to determine or discuss with the proposed board whether alternatives to guardianship or supports and services are available to avoid the need for the guardianship, and discuss the attorney ad litem's opinion with the ward. And that can obviously be a very difficult situation when you're having to discuss with your client that you believe the guardianship is necessary based upon certain factors in their case, or it's required to certain extents, right? And so, but again, it's that importance of having the discussion with the individual about their lives. And so this change is important to that person-centered idea and making that purpose statement in the beginning of the code possible. There's a duty of the guardian ad litem. A guardian ad litem must consider the necessity of the guardianship and evaluate alternatives to guardianship and supports and services that would avoid the need for the guardianship. And there's a duty of the physician in determining capacity, and in making that assessment, the proposed board's ability to make or communicate responsible decisions concerning himself or herself, including administering to ADLs with and without supports and services, the proposed board's ability with supports and services to live in the least restrictive setting, and whether a guardianship is necessary for the proposed board, and if so, whether specific powers or duties of the guardian should be limited if the proposed board receives supports and services. In this particular scenario, we see on the national level with the ABA and the Committee on Assessing Individuals with um, that have developed the assessment manual on assessing elderly or disabled individuals in their capacity. This impelling in its newest edition to use physicians that have specific treatment to assess someone's psychological condition, and not just um, using a PCP, a primary care physician, right? So that we have the best assessment possible. And then, just as a general note, the new assessment manual or handbook also includes an assessment tool for the lawyer as a practitioner. So it's a great resource for that as well. So similarly, the court has a duty to consider alternatives and supports of guardianship, and must do so if it finds that a guardianship is necessary with clear and convincing evidence, a pretty high standard, right? Um, Whether or not alternatives to guardianship that would avoid the need for the appointment of guardian have been considered and determined not to be feasible, and that supports and services available to the proposed ward that would avoid the need for the appointment of a guardian have been considered and determined not to be feasible, right? So everyone throughout this process has this requirement to consider the needs of a guardianship. And certainly that doesn't stop with the court. The court is the one that's going to put the order in place. And therefore, the code makes it very clear from the compliance of a CME, from the court's finding and the evidence before it, whether or not this guardianship is necessary and to what extent it is. And then there are specific duties as to restoration. A guardianship must be closed when the court finds that the ward has full capacity or sufficient capacity with sufficient supports and services to care for himself, herself, or their self and manage his, her, or their property, right? And so that's kind of what we're looking at in this idea of Britney Spears, of Nichelle Nichols, or Uhura, right? Are they able, with supports and services, to manage themselves or their finances? Would their assets being placed in trust be sufficient for them to have their rights be restored as it relates, or in some capacity, to their estate? In Texas, an order modifying or terminating a guardianship must state, if applicable, any supports and services necessary for the restoration of the ward's capacity or modification of the guardianship. I think a lot about the case of Britney Spears in terms of this idea of restoration, and what might that have looked like over a 10-year period. Was there ever a plan in place by the conservator? Reports would suggest that there wasn't. But what might that have looked like? Would that have been a care manager that helped her with supporting and coordinating services if she was unable, or documenting that she didn't need the help at all? Would it be giving her a more substantial savings budget to see if she could manage savings beyond the reported $2,000 monthly allowance or weekly allowance she received? Right? So there has to be some tools we're giving the individual that maximizes them, that gives them towards that trend, gives them some evidence toward that trend of to removing the strictures of the guardianship piece by piece or in totality, right? And so when we look at these case studies, that's part of what I'm looking at. What has been done to help this individual live their own lives? And does there appear to be evidence sufficient that either with help or without it, they're able to um, be free in some capacity of the guardianship? And then we have the story of Wendy Williams, and I couldn't do it without giving you "How you doing?" Right? That's her famous phrase from her show. Wendy Williams is a TV and radio personality. One, I guess you could say, former. I guess she's not. She lost her role with her show. She's or She has been, that employment relationship has been terminated, according to most recent reports. She was diagnosed with Graves' disease, an autoimmune disease, and part of the related symptoms someone could develop with Graves' disease do include some psych symptoms, according to available medical research. And she took a break from her show in May of 2020 for the purposes of dealing with fatigue caused by the disease. Williams says that her accounts were frozen after she started asking questions about her money. Wells Fargo filed their petition under seal, right? They gave her some level of privacy. Um, what the nature of that is, being that she's so famous, other than the fact that we can't you see the pleadings in the court record, not sure, but they did some, I guess, maybe perhaps courtesy by filing it under seal. Her advisor, Lori Schiller and Wells Fargo, had filed a guardianship proceeding due to reported concerns for her. They have admitted with public statements that there are strictures on her account or accounts, and they've advised the court that they are open, whatever that means, to releasing funds to normal creditors for her to pay her bills, right? And so we have this question, this ongoing dialogue in the case of Wendy Williams of how you doing, literally, how is she doing? Um, there's not a lot of detail in the conservatorship or guardianship that's been made publicly available, but we do have the question of someone with as significant resources as has been reported by various sources, why those things could not have been placed in a trust with Wells Fargo's trust division, right? Why she couldn't be dealing directly with that division and taking this advisor out of the question. Um, those are some of the things we might be looking at in a case like Wendy's, who seems to be outside of the issue of managing her finances, according to Wells Fargo and Ms. Schiller, managing her life otherwise well. So, is there a need for some protective proceeding or measure, and limited in scope, for her to manage her finances? According to most recent statements by Williams, she feels as though she needs no assistance with her finances and wants direct access to all of her funds. There are reports that she is having to borrow funds to pay for just the needs in her life at this time due to constraints that have come about with this issue of Wells Fargo. And so when we look at this story, it's very interesting when we look at our most recent stories about conservatorship and guardianship, they include women. And a couple of the more recent examples include women of color. Is it playing on these ideas or this assumption that this person needs help for certain historical, perhaps misogynistic rationale? Are the people assessing these cases really looking more broadly at the actual facts of Wendy's life and her needs, right? What discussions have been had with this individual person about their needs other than a shutdown of their accounts? It's a very important, I think, lesson that can be learned. It's something that certainly happens, um, not just to those who have a lot of wealth, right, a higher net worth, but that does happen to people who have lower net worth. That happens here in Texas, where accounts are shut down and individuals have to kind of fight with the bank about getting access because someone said they doubted their capacity. And of course, here in Texas, we have statutes where banks do have to consider by law whether or not there's fraud, exploitation. Um, and we don't want to fault them for doing something if they believe there's some level of um, financial mismanagement by the individual unintendedly or by someone else. But then we still bears out the question that in this case the financial institution went even further. They are the ones who filed a petition for guardianship and are actively seeking court intervention. They're not doing an interpleader and saying, "Hey, judge, I'm out. Just help Miss Williams, you know, let us know how that goes." It seems like there's a more active role in that case, whatever reason that may be. So when we're looking at interventions, this case study is interesting in that regard, right? The layers of intervention possible. from a theoretical standpoint, and then the layers of intervention that are necessary. So when considering a guardianship, I have developed my kind of own decision tree. I think everyone needs one when they're thinking about guardianship, conservatorship, or protective proceedings, to kind of go through the analysis and all these factors we've talked about that are in the background. So in sum, my process is this: consider the policy and purpose of the guardianship. Are we that in Texas specifically, is it about that individual's needs, and are we doing it in such a way that maximizes self reliance, independence, the individual? Determine the level of capacity involved. There are layers to that thing, right? It's more than I could get into this presentation, but the levels of capacity there are. And Judge King has written on this very topic on these levels of capacity in various articles, and I would definitely refer you to his materials, considering levels of capacity, defining the needs of the individual. So, what if the individual does have issues with capacity? Do they have actual needs that need to be addressed? Determine whether those needs are being met. As I said, consider alternatives to guardianship and supports and services. Can that individual use existing means or modify, employ some or modify what's going on in their life to avoid a guardianship or a guardianship that may be plenary or full? Determine the less restrictive alternative. So, if we do have to have a court involvement, if we do have to have protection at all, what might that look like? In the case of Miss Williams, does that involve, it could involve a private trust? Do we even need to have an incapacity finding by a court at all? May she place her assets in a private trust that avoids the need for this guardianship? Is that an option available? Have we gone through those layers of decision making to determine that we don't really need a court administered trust, but maybe a private trust, one that names someone else as co-trustee, a trust protector, um, you know, uh, if a guardianship is necessary, if this individual doesn't have capacity, and we've gone through those other layers. So then, after above, after the above, are needs still unmet? Consider the least restrictive guardianship possible, right? So if we go through these broad case studies and say, when we unpack these layers, be it from the issue of finance to the person, we've given them all the tools possible, either self-directed or assisted. Um, then we create the guardianship. Then we look at that as the final layer. And so I have one example that I'll go through with you that I use frequently on presentation in this issue of alternatives in guardianship, of just a plain person. Again, I think the guardianships from the headline are great to think about because they bring attention to issues, but they're not issues that are uncommon. They're not issues that uh, quote normal people, I guess if you can say that, but others going through the guardianship process um, have to confront. So let's look at the story of Laura. She's 17 and going to be aging out of her school and extracurricular programming. Her parents, Carl and Harriet, are avidly seeking guardianship of their daughter, who has had inclusion classes throughout much of her K through 12 education. In fact, she has a gap between 60 and 70. Laura's parents have secured a capable attorney who has applied for guardianship, alleging that Laura is totally incapacitated. Laura's AAL, Eddie, disagrees with the petition. In fact, Laura's AAL believes Laura can complete executing guardianship alternatives. So, observations. Did applicants' counsel ever actually meet the proposed ward? I'm a proponent if you can. If you're involved in a guardianship proceeding, meet the proposed ward, get to know them, know about them before you apply, you contest, you intervene. Did the applicant's counsel perform his or her or their own capacity assessment? Um, do you have tools available? Have you defined your own metrics of how you assess an individual's needs or capacity? If the applicant's counsel did meet the proposed ward, did he, she, or they admonish the proposed ward as to who he or she they represents? That individual, um, many individuals under a guardianship still have the ability to communicate. They have the abilities to understand to varying degrees, and so it's important for you to otherwise do what you would otherwise and admonish people as to who you represent. Did the applicant's counsel have a CME done and reviewed prior to filing a guardianship application? That's certainly important. If you're going to go down the route of guardianship, have a certified medical examination report completed. And ideally, it would be by someone who is a specialist that has the ability to assess individuals' mental capacity and not just the PCP. I mean, not that that doesn't have weight, not that they haven't done rotations in psychology or psychiatry, and no one's downing a PCP. But we're looking at primary care physician. But if we're looking at particularly in this case for Laura, someone who is on a spectrum and does have capacity to do self-management on various things, then affording her that assessment by a specialist, if one is available, would would lead further down the road a discussion of reliance and independence. So step two, Eddie has his first meeting with Laura. He inquires about Laura's day, who's the president, the day of the week, where she lives, why he's there and interviewing her, and feels as though she has a baseline orientation based on Laura's responses. Eddie inquired about Laura's friends and desire to be independent. Eddie also asks Laura about her parents applying to be her guardian, and she feels as though she is capable to manage her own affairs. Eddie files his answer and advises the applicant's counsel, Steve, that the guardianship should be reconsidered. In Eddie's assessment, while well intended, he did not push the questions far enough. For example, had he asked to see Laura's room, he would have seen that Laura actually destroys half of the objects in it. Though Eddie did ask if Laura had friends, he did not ask how they treated her. If he had asked, he would have learned that her friends make her pay for their meals. Though Eddie did inquire about Laura's opinion on the guardianship, he did not share with her that he believes that Laura has diminished capacity and may need assistance. So things may not be rosy, depending on either side or all sides of how you look at further inquiry in a guardianship, but certainly they're necessary to understanding the individual and the totality, the to the best one I guess ever could, their needs and any issues they're confronted with. And then our final step, because I'm running out of time, out of concern for his client, Eddie conferences with Steve and Laura's parents' attorney about the need for the guardianship. After conferring with the parents, Stephen shares that the parents are concerned about Laura's ability to judge character of others and her ability to make appropriate decisions regarding her residence. Eddie, in speaking with Laura's school, learns that Laura's art, focusing on her transition beyond high school, indicated moderate hope for the ability to adapt and transition into independent living. So, what are Laura's needs? Food, clothing, shelter, money management, socialization. Um, does Laura feel that her current needs are being met? Does Laura provide some of her own needs? Does she do so with informal support from parents, school, friends, or others? There are a lot of questions that go into Laura's life and how things happen the way they happen. And these are important ones to understanding the nature of any protective action that might be taken. And I think, okay, so after talks, I have time for one more. After talks with Harriet and Carl and their attorney, Eddie must go back to his client to discuss the nature of the guardianship, if any. Speaking with Laura, he learns that Laura is on an interest list for supported living environment. Further, he learns that Laura will be eligible for SSI benefits on her 18th birthday, as her parents' income has prevented her eligibility as a child due to applicable deeming rules. Armed with additional information and support, everyone gets together to recommend that what if any, guardianship would be appropriate. In this particular case, with all those supports and services, it would seem like a supported decision-making agreement could be appropriate. Um, it may not be, but it's certainly one that should be part of the discussion. And I think, and that's the last slide there. When we can take the examples of Britney Spears, Wendy Williams, Nichelle Nichols, and look at them as very popular examples, but they do represent um, a struggle that many people are facing, the needs that people are facing. Um, and I think if we go through this analysis, we can see that they're people too, and they are in need, as we all are. If we were to go through a guardianship proceeding with some thoughtful analysis of how we can trend towards someone's uh, reliance and their maximization. And I want to thank you all so much for joining me today. It's been great to share these stories with you and talk a little bit about guardianship, its history, and its relevance today. Thank you so much.